I'm joined by attorney Pete Festa from RF Injury Law, offices located in Manhattan, and soon to have an office on Bergline Avenue in West New York here in Hudson County. Mr. Festa, thank you for joining me today on Hudson TV.
Thank you for having me today.
I wanted to talk to you about the potential scenarios that could happen involving a case that was just announced by the Hudson County Prosecutor's Office the other day, basically involving a 24-year-old babysitter from Union City who's been charged with endangering the welfare of a child in her care, that child being a 2-year-old girl. Injuries reportedly to the child's back, some injuries to the leg. They did an investigation over what I believe was a course of several months, and the information was just brought to light. Her now being a defendant in this particular case, what type of scenarios, what type of options are open to her in order to defend herself against these charges?
Well, first, I would point out that when you're charged with endangering the welfare of a child under the current New Jersey Criminal Code, when you are in position of authority or you have a legal duty over the child, it elevates what is otherwise a third-degree crime to a second-degree crime. So the woman in this particular case, it's alleged that she was the babysitter. So that would enhance her duty of care. It would put her in a position of having legal duty over the child. So she's facing a second-degree charge, which in the state of New Jersey, that at least the range for the sentence of a second degree would be a 5 to 10 year state prison sentence. So that's really what our starting point is. As far as what the procedures would be and what her options would be, it starts as we both looked at that article. It indicated she was arrested either on Tuesday or Wednesday of this week. Within one day, she would get a central judicial processing hearing, and then it's at that hearing that the prosecutor has to decide whether or not they're going to file for a detention hearing. Likely with a second degree, they would file for that. The detention hearing usually takes place within 3 to 5 business days after the initial central judicial processing hearing. So what this defendant would face at that point is they would either hire an attorney or obtain the services of the public defender's office, who would represent them at this detention hearing. A detention hearing usually is governed by a document called a public safety assessment. And essentially that assessment focuses on 2 primary factors. The first evaluation in that assessment is the criminal record or lack of a criminal record of a given defendant. And then the other section and the other factor that applies is the failure to appear aspect of this person's history. So depending on how the numbers come out is how us defense lawyers talk about it. The lower the numbers, the greater chance of release. The greater the numbers, and they go from 0 to 6, the greater the numbers, the greater chance of her being detained. So that is what this defendant is looking at and dealing with pretty much as we speak. So that's where the case is right now.
So in this case, let's assume that this is a quote unquote first time offense for this individual. What is the likelihood that the prosecution side and the defendant side are able to come to an agreement in some manner of speaking to avoid going to a trial? How likely would something like that be versus someone who is not a first-time offender, has got a past record? Talk about that a bit.
Certainly. So, and it's a great question. And it sounds like a simple question, but there's a lot of complexity to it, and I'll break down my answer as follows. The answer itself, the time frame, really depends on the result of this detention hearing. A defendant that is released is not under the time restrictions, I should say, of bail reform. That means the case can sit what's called the pre-indictment conference phase for a much longer period of time. And I think that in a case like this, it would give a greater opportunity for both the state and the defense attorney to conference, to negotiate, discuss, and try to come to a resolution. If the defendant is detained, there are very strict time restrictions on when the case needs to be indicted and how long the prosecutor has before the case needs to be resolved. Those restrictions to some degree have been relaxed under COVID regulations and protocol, but we're coming out of that now. So my experience with my cases has been that these restrictions are in place, and it just gives less time to really sit and look at the case. So assuming that they do have the time to look at the case, I would evaluate this case even on the limited facts that we have as follows. First, you have a relatively young, at 2 years old. Difficult really for a 2-year-old to get up in court and testify. So that becomes a little problem for the state. I'm sure that the state, in taking that months or so during its forensic evaluation, has some evidence, and we don't know that, but they must have something pretty significant in order to bring the case and move the case forward. Right. From the defense point of view, I'm assuming that this defendant has very little or no record. She seems to be, I believe she's 24 years old. She's a babysitter. It's not like this is a drug case or a violent, street case. Not to say that there's not violence in this case, but I'm just trying to get a little flavor of what her background might be and how the state may look at this. And the fact that she's charged with a second degree, and like I said, it's 5 to 10 year range. The key to with the differentiation between a third degree and a second degree is, as a second degree, there is a presumption that a defendant, if they are found guilty or plead guilty, will in fact receive a state prison term. If it's a third degree, the presumption is that they would not. Here, even with the presumption, I think that as a defense attorney, I'd be arguing, the case is overcharged. It's not a second degree charge. It should not be a second degree charge. It really falls more in the third degree. And if they would modify it from a second to a third degree, it puts probation, and it may even put pretrial intervention on the table, which is a diversionary program similar to probation, except that the defendant not have a record at the end of a PTI. So that midpoint between that third degree and second degree is very crucial in a case exactly like this. I think that would be the back and forth that would take place in this negotiation. And obviously, depending on the strength of the state's evidence, the defendant would be looking to avoid jail time at all costs.
Let me ask you one final question. We obviously don't know if this babysitter had ever cared for this child before, what the relationship might have been with the child's parents or guardian, whatever the case might be. If this were to go to a court case, a trial case, what would be the likelihood that either side would have the parents or the guardian provide testimony? And which side would be more likely? Or is there even a possibility that both sides could call parents as a character witness in some respect?
Great question. And as you said, it's a little bit difficult because we're not dealing with the full file. We're not dealing with, the contents of the discovery, which essentially would be the contents of the prosecutor's file. But in cases like this, especially where you have such a young victim, it's virtually impossible for a 2-year-old to provide any testimony. So I think that it would be extremely likely that the state would rely on the memory of either both or either of the parents, depending again on how the discovery falls. And yes, it might be possible as a defense attorney for this young defendant that you would want to at least have the investigator speak to the parent or parents of this child, and determine whether there's anything that they might say that might help your case. To go to trial on a case like this, I number one, from the defense point of view, you're going to trial on a case where there's a presumption, if found guilty, there's a presumption of incarceration. So there's that danger from the defense point of view. From the state's point of view, even without me knowing what the forensics show or the rest of the remainder of the facts, there is some difficulty for the state because they don't have a victim that can just put on the stand. And in my experience, juries, they're looking for that. We have to remember that in the state of New Jersey, really all over the country, the standard of proof, the burden of proof is borne by the state, and it is beyond the reasonable doubt. They have a tremendous burden. So I see the trial being problematic from both sides. I think that the case would do well to be thoroughly negotiated and conference between the prosecutor and the defense attorney, and that a resolution might be able to be found by way of a plea bargain out of court.
Right. Well, any way you look at it, a sad case in every respect, obviously, So I appreciate you breaking it down for us, Mr. Festa, given the fact that we don't know all the specific details, but good explanations, and I appreciate your time. Thank you very much.
Thank you, sir.